Welcome to our webinar on privacy, on the subject of how will the coronavirus affect Washington's privacy policy debate, what are the trade-offs, and who should make them. I'm Tom Leonard, Senior Fellow and President Emeritus at TPI. So Congress has been debating federal privacy legislation for some 20-odd years with increased urgency during the past year following the implementation of the GDPR and the passage of state laws in California and other states. And when Congress takes up this issue again, as it undoubtedly will, the debate is likely to be somewhat different due to the data needs and the uses that are associated with the coronavirus and its crisis and its aftermath. So much of the pre-coronavirus debate revolved around whether legislation should preempt state laws and whether there should be a private right of action. Obviously, these are important issues, but that debate somewhat obscured questions that may be more fundamental, particularly in the context of a major health crisis, how to make the inevitable trade-offs and who should be responsible for making them. These questions need to be addressed to assure that any new privacy regime yields net benefits relative to the current regime. And we have a very distinguished panel to discuss these issues. Unfortunately, Julie Brill, who was originally on the agenda, couldn't make it, but I think we have great remaining panelists. They are Jane Bambauer, who is a professor of law at the University of Arizona, Alan Rawle, who's the partner and leader of the Privacy, Data Security, and Information Law practice at Sidley Austin, and Liad Wagman, who is a senior economic and technology advisor, the Office of Policy Planning, Federal Trade Commission, as well as a professor of economics in the business school at the Illinois Institute of Technology. So we have two of the leading privacy scholars in the country, Jane and Liad, and one of the leading privacy practitioners. So I'm going to start out by asking the very basic question, and maybe each of you could answer it in turn, starting with Jane. Has the trade-off between privacy and the beneficial uses of data been changed by the coronavirus pandemic, and if so, how?
I think so, or at least I hope so. I think that the pandemic has revealed the ways in which trade-offs need to be made with privacy, but not just that. They need to be made in a way where there's enough clarity so that data can be shared in real time and when it's most needed and most important. So I hope that as we learn more about the ways in which the Western response to the pandemic differs from places like South Korea and Singapore, which have had have done a much better job of containing the spread of the virus while also not using draconian lockdowns. I think we'll see that if privacy is kept in a perpetual state of regulatory uncertainty, there will be too much anxiety and uncertainty about sharing data on, say, geolocation and or even health status that winds up, in service of privacy, winds up compromising other liberties that are ultimately more fundamental. The other thing I'd say before turning it over to the panelists is that
you mean like the liberty to leave your house?
To leave your house, yes. Yeah, we are all under house arrest right now, which, right. And I find it striking that, most actuals seem to agree universally that the government should force us to stay home for an indefinite amount of time. And yet there seems to be a lot of hand-wringing and controversy over the idea of sharing cell phone digital data in order to facilitate, simultaneously facilitate containment of the spread and, getting the economy back working. And so I find that a bit ironic. I mean, for me, that seems like a perversion of the order of our priorities. But I also understand one of the fears is that if data sharing is made much more available during a crisis, that same data can be used for a range of purposes. And I think that just points to the need to define bad uses and good uses in advance to the extent that we can do that.
Right. And I mean, the type of data you're talking about really is, I mean, in the context of a pandemic, where there are all sorts of societal repercussions, it's not kind of an individual decision, just like in the same way that, I guess, in general, whether you have your kids vaccinated probably should not be just an individual decision, because it affects a lot of other people as well.
Yeah, that's true. But I also think that to some extent that very same principle applies when the stakes are lower as well. So even if we think about something like credit reporting, what it means to be creditworthy is ultimately a kind of relative thing. And we could go to things that are even less important than that, advertising. And the trouble with privacy as an individual right is that many times the information is most useful and when it's used in a sort of collective way.
Liad?
So I can pick off exactly where Jane left off. There's a study of mine I recently completed on the effect of certain loosening of privacy regulation after the 9/11 attacks. And what happened then was that 19 states adopted Patriot Act-like modifications to their wiretapping laws, basically loosening the rules around using them in criminal prosecution. And the trade-off there was between security and privacy, and kind of similar to the trade-off that we're facing now with the coronavirus. And obviously different context, different timeline, but those 19 states that adopted the looser wiretapping regulations ended up showing increased productivity in pursuing crime in terms of increased arrests, increased convictions, basically putting criminals away. And those laws that they adopted largely stayed on the books 18 years later. This kind of points to some sort of a preference shift, perhaps in society, kind of in between this trade-off, this spectrum between privacy and security, a little bit more towards the security side, at least in those states and at the federal level with the Patriot Act. So it's possible that coronavirus is leading to a similar shift in societal preferences that might, weigh a little bit more towards security. It's hard to tell when you're in the moment, but we can look at it sometime later and see if that was indeed the case.
Alan?
Sure. I'll pick up where Liad just took us with the trade-off between privacy and national security. I had the honor of serving as vice chairman of the Privacy and Civil Liberties Oversight Board. The first iteration passed in 2004 after 9/11. And we were very much of the mindset that we would avoid the notion of trade-offs, that really what it was is a balance and achieving both the objectives of privacy as well as effective national security. And that with sufficient safeguards on the protection of privacy and checks and balances on the exercise of the national security authorities, that in fact there wouldn't be a sacrifice of privacy because there would be an increase in safeguards. So greater powers of surveillance would lead to greater oversight and checks and balances and safeguards, including with the Privacy and Civil Liberties Oversight Board, but with the Inspector Generals of the different national security agencies. And that mindset, I think, very much has always infused our national security, as well as, to I would say, not quite the same intense extent for law enforcement, where when we've done comparisons of the checks and balances and independent oversight the United States national security legal authorities for monitoring and surveillance to fight terrorism and counterintelligence, and we compare that with those of Europe, we actually have seen that the safeguards and checks and balances are stronger, I believe, and was the co-author of a report that so found, than those in Europe. So that takes us to what's happening in Europe, what's happening in the United States and around the world on privacy with the coronavirus. I agree with Jane very much that we do see a ground shift among various key players. For example, the European Data Protection Board issued a statement on March 20 in which they said that European data protection law, in particular the General Data Protection Regulation, was not going to stand in the way of effective efforts to combat COVID-19. And then they listed out a number of different factors that would ensure that any use of personal information would be proportionate and subject to safeguards and so on. But the key point is there was a recognition right away by the EU, the European Data Protection Board, that the privacy laws couldn't stand in the way of this. I think we're seeing the same kind of positioning, reaction from the privacy advocacy groups, the NGOs. We've seen a number of statements that have said, use of aggregate data, use of anonymized data, use of personal data with appropriate safeguards that doesn't lead to greater surveillance, that isn't going to be used later, repurposed for other reasons, is necessary, essential to protect us all. So I guess I would say that there's a recognition that privacy is a fundamental right. I think it is, in the Western world, the Europeans, the EU under GDPR like to focus on its being a fundamental right, but they make very clear, as does the Court of Justice of the European Union, that it's a fundamental but not an absolute right. I think the same holds true in the United States. So there needs to be a balance. I think a couple of observations I've made before turning it back to you, Tom, is that while there is a recognition on the ground, a very real one, that we can't let overly restrictive privacy concerns inhibit what needs to be the right to go outside, the right to not be placed on a ventilator, and so on. But at the same time, the interest of society broadly, the public, not just the NGOs, not just the European regulators, is that privacy actually is a really important value. It's just that we need to be reasonable about it, balance it, and provide some safeguards. Recognize that it's fundamental, but not absolute.
So you're talking about the European data privacy framework, and you're talking about the repurposing of data for uses that were not originally intended. Kind of leads me to my next question, which is, I mean, we know the approach that's been followed in the United States with the FTC as the primary privacy enforcer is basically kind of an ex post enforcement regime based on actual privacy harms, in contrast to the European approach and the approach of the CCPA and other approaches of the fair information practice principles, which is kind of a prophylactic approach, which is kind of intended to place barriers on the collection, use, sharing, repurposing of information to guard against hypothetical privacy harms. So, so my question is what are the implications of these two approaches for uses of data in connection with the coronavirus? For example, you say, well, you talk about repurposing now, but there may be data that was collected way in the past that could be repurposed at some point to study some of the impact of various remedies to the coronavirus, things that we haven't thought of before, or things that, we won't have thought of until the future. So how do you compare the two approaches in terms of which one might be better, or what their implications are for the use of data in connection with something like the coronavirus? Jane, you want
Well,
Oh.
if you want me to take.
Yeah, sure.
Yeah. So, I think your point that the U.S. model, especially with the, post hoc enforcement where actual harms or abuses have been identified, actually has worked very well in the United States. The Federal Trade Commission, over many decades and different administrations, let's say subsequent to, starting in the 80s perhaps, has actually exercised its prosecutorial discretion, I think, with very sound judgment, and really does make an effort to balance those harms. I would say we don't always see the same exercise of judicious prosecutorial discretion coming from the states or from plaintiffs' lawyers, which also form part of the kind of nuclear triad of disciplining privacy and cyber abuses. So I think it has worked well, and the enforcement in the United States from the FTC, state AGs, HHS, et cetera, has really been at a level so far beyond the enforcement that has been seen in any other country, including in the EU, that I think you'd have to say that where there are real abuses, there's real enforcement to penalize, deter, and sanction that activity. So I think our model works well, but I think that there is a, society in the digital age has gotten more complex. Regulation, appropriate regulation. There are interstices that the current, enforcement model may not pick up, and the public is just much more attuned to privacy. So the notion of having a comprehensive omnibus law at the federal level, even though I would submit it shouldn't follow the European GDPR model or the California Consumer Privacy Act, the CCPA, that it really should be one, as you said, Tom, that identifies the harms that society desires to prevent and ensures that they are regulated and restricted and enforced against in a way that takes the overall interests of society, which includes freedom of choice for consumers, the right to technological innovation to be attempted by companies and to be received by consumers. So one of the things that we don't see very much, to some extent in the GDPR, perhaps to a lesser extent in California and a greater extent in the Washington state legislation, is really kind of identifying what are the harms that society wants to stop, and are they in fact unreasonably offensive, highly offensive to average citizens, or is the regulation of privacy out of the GDPR, for example, more focused on bureaucracy than on protection? So I think federal legislation, if we ever get there, Congress can come back or decides they can vote virtually, really should take into account more of a harms-based model than we're seeing, I believe, out of CCPA, GDPR.
So you've written a paper on harms. Jane wrote what I thought was a very interesting paper on harms connected with the Cambridge Analytica episode. Why don't you both discuss a little bit more how you think harms? Well, Jane, why don't you start, and then we'll get to Alan, and hopefully we add. What should be our approach to harms?
Yeah, well, first of all, I just want to concur with Alan that the harms-based approach has worked well. And there's this, I think, a misconception that if privacy is a fundamental right, you must regulate it in a European style, GDPR style. And that's just manifestly not true. There are many fundamental rights, like even considering, for example, where no one would disagree that that's fundamental, and yet our negligence law, for example, uses risk as its main measure, foreseeable risk as its main measure of whether some activity is legal or not, rather than having a sort of individual consent-based model. So for harms, I've written that one problem here is that consumers, although they want choice, they often lack good information about what their choices ultimately will do for them. And there are many times where where privacy may wind up not working to their advantage. Liad has written many of the best papers that look at what, for example, changes in default rules on data sharing wind up doing for consumers, for example. And so to define a harm, I've played with a few ideas. One is that if well-informed consumers who understand the ultimate use and sort of risks and benefits of data, find some kind of collection or sharing or usage to be offensive, then that decision should inform what it means to be a harm, and regulators should treat it as such. So that's a way of defining harm without being specific about what sort of philosophically we're looking for. But the other thing I've been thinking about recently, since that Cambridge Analytica paper, is trying to design a privacy policy that addresses what I think is the real affliction, which is that consumers feel like being exploited, and I'm not sure that so first of all, I'm not sure that descriptively it's as true as consumers think it is. In fact, I think it's often not true that consumers get a lot out of data sharing. But more importantly, I think that if that is one of the major problems here, it makes more sense. It's more, it's incumbent on businesses to start thinking about the ways in which they can show their users, their end users, that the collection of data is really working for them, whether that means profit sharing or even just simply educating on how data is used in a way that is both credible and just kind of remove some of the tension. So if there is a federal law that eventually gets enough steam to move, I hope that we will learn from the from some of the wisdom of the FTC Act enforcement. And I agree with Alan that I think California's law in many ways can be understood as a model for what probably won't work for the country.
Well, one piece of empirical evidence, I guess not directly relevant to not directly on California, but on the GDPR. I mean, Liad, you did a pretty widely cited article with a couple of other people on the effects of GDPR on various sorts of investment. You want to just summarize briefly what you found?
Sure. So first, let me just state that the FTC chairman did publicly say that there should be a federal privacy legislation that increases deterrence and creates some sort of mechanism for reassessment over time as technology changes. But the chairman is also cognizant of the interface that data regulation could have with, say, competition. And that's where this GDPR paper comes in. So this GDPR work looked at this interface, and let me just say, there are some dimensions in which data regulation and competition can be complementary. There are others in which they might be in conflict. So for example, with GDPR, which is a transformative regulation that touches across sectors and implements several different, distinct, and big changes, we see that venture funding in the European Union, after its start of enforcement, after the start of enforcement of GDPR, has declined substantially. And we see that in the number of financing deals that ventures are able to secure, number of financing rounds they're able to raise. We see it in the dollars that are raised per an individual round on average. And we see it in the total dollar amounts that is being invested in European countries in technology ventures. And so there's some clear indication there that there's an impact on the youngest, the smallest, and the consumer-facing ventures. So that is a cause for concern. And this work is not standing in isolation, right? There's other works around it that point to similar effects. There are also micro foundational, in some sense, models that predict this sort of effect. Those models were written, years earlier, and essentially said this is likely what's going to happen. So I can't say the empirical results came as too much of a shock, but the magnitude was surprising. The magnitude is really high. The other things we're seeing is that foreign investors are pulling out from European technology ventures more than domestic European investors. So there is something in GDPR that pushes foreign investors away. It could be uncertainty about how the law is going to be enforced. It's yet to be determined. It could be that those investors have better options elsewhere. It could be that they prefer to invest under the U.S. approach.
Is there evidence that investment has increased in the U.S. or other countries that were not at least directly affected by GDPR?
Right. So the way the analysis is conducted is using what's called a difference in difference approach. So we're looking at the difference in investment in the EU before and after GDPR. And we're looking at the difference in investment in, say, the US or another control group before and after GDPR. And then we take the difference between these two differences to see if there is a significant effect on the treatment group, in this case, the EU, as a result of the law. What I can tell you is that investment in certain sectors has increased in absolute terms. For example, the data security, data privacy sector, we do see increased investment. We see increased investment in both the US and the EU, but that sector is too small to have any dent in the bigger picture. Another study in this context that kind of points to the trade-offs had nothing to do with GDPR. In fact, it had to do with Gramm-Leach-Bliley in the US, where several counties adopted an opt-in approach where data would not be sold unless consumers gave explicit permission. And neighboring counties stuck to an opt-out approach where data would be sold unless consumers actively opted out. And as you know, this default matters a great deal, right? Consumers tend to go with the default. So the opt-in model amounted to effectively a ban on trading in consumer data, whereas the opt-out model was effectively free reign to trade in it as you want. And so the opt-out model led to more data collection, which you might consider as potentially harmful to consumers, but consumers benefited from lower prices in that model, less issues with a mismatch between the customer and the loan, and less foreclosures, fewer foreclosures downstream. So even in that isolated setting where the only change is the default, the opt-in and the opt-out, we see that there are drastic effects. And so I agree with Alan and Jane. There are clear trade-offs and we can point to them. At the same time, there are cases where there are no trade-offs, right? For example, nobody wants to be stalked. Nobody wants revenge porn to be posted about them, right? Nobody wants to be part of fraud, right? In those cases, if we can identify those cases, we could create rules and use a harms-based approach that addresses them, right? So I think there is opportunity to do things that are meaningful, that consumers care about, and that are not harmful, through some indirect effects. Both competition policy and privacy policy are aimed at increasing consumer surplus. Right? So when the two are in conflict, it raises questions about where the balance should be struck.
So there seems to be fairly widespread agreement that we need a federal privacy law, and I guess there are various things behind that. But But to start with the basic question, in what way is the current approach inadequate? What does the current, I mean, I can understand people think, well, Europe passed this law and California passed this law. We got to do something to rationalize the system. But, you know, kind of getting beyond that, in what way is the U.S. Regime inadequate? What problems need to be solved that it is not solving?
Well, you know, one of the, I think Liad mentioned some concrete examples of like nobody wants revenge porn. Jane mentioned Cambridge Analytica situation, which I'll kind of expand or generalize up to kind of disinformation, where third parties like the Internet Research Agency, tool of the Russian government and other allies of the Russian regime, were able to we were able to see how effectively we could be manipulated by the combination of micro-targeting and disinformation, false information, and targeting certain groups in a way that the rest of the non-targeted communities didn't even know it was going on. I think that was a very powerful factor in 2016, as many studies have shown, and while the Mueller report is cited as a prime example, one that was forgotten was the Senate Intelligence Committee under Republican leadership documented the disinformation and manipulation of the US citizenry in 2016. And if that isn't a concrete harm, I really can't imagine anything too much worse. But what I would say, the risk of not focusing on harms is that we could go the way of just presuming that any use of data, personal data, is presumptively risky and harmful, and then apply kind of a precautionary principle to it, as I would submit the EU often does, and say that unless you have some express permission or a clear mandate in black letter statutory law, then any use of such data is, again, presumptively unauthorized or suspect or problematic. Very frequently at hearings on privacy and in conference on privacy, you really hear talk 99% on what the solutions should be, what the regulatory factors should be, and very little discussion. Okay, what is it that really hurts people and that people are really worried about, and to characterize those harms rigorously. Tom, you were nice enough to mention the harms paper that I did on behalf of the Chamber of Commerce Institute for Legal Reform and submitted publicly to the Federal Trade Commission. And I'm hoping Liad will read it if he hasn't had a chance to, where we really argued that the FTC framework should adopt an effort to really understand what is it that actually hurts people. And when I say concretely hurts people, I don't mean that it needs to be just tangible injuries. If we turn to the Supreme Court decision in the Spokio versus Robbins case, which was under the Fair Credit Reporting Act, the court said that in that case, there was not standing under Article 3 because the alleged injury wasn't sufficiently concrete to sustain a case or controversy as required by Article 3 of the Constitution in federal courts. But significantly, the court did say that intangible injuries are also actionable if they are concrete, if they actually cause damage. And the court also said, in a sophisticated, nuanced, statement or explication, that concrete, tangible injuries are easier to recognize and therefore tend to kind of dominate harms discussion. But it's also true that intangible injuries, which are not, are harder to recognize, but they can have significant impact. And I think that what is important is to engage in a cost-benefit analysis, even for something that is as, let's say, abstract as privacy, and where human dignity and emotional impacts and chilling effects is relevant, that it still needs to be subject to a rigorous cost-benefit analysis. I mean, if we can value human lives in order to implement environmental regulations and food and drug regulation, all, concretely taking into account what the costs and benefits and risks are going to be, we can do that for privacy. And, administrations past of both parties have promoted, supported cost-benefit analysis for federal regulation under the aegis often or tutelage of the Office of Management and Budget, the Office of Information and Regulatory Affairs. And, someone like Cass Sunstein, who was, in the Obama administration, the OIRA regulatory czar and also a proponent of cost-benefit analysis, he would concede that cost-benefit analysis applies even to intangible injuries, and we just need to find a way to value it, weigh it, and assess it against the impacts, the lost impacts of choice or innovation, flexibility. So I think that what we need to do is really kind of stand up for what has been kind of more of the US focus to identify harms and target that which is seriously problematic, and not presume that uses of data are inherently evil and should be discouraged. And so I would say cost-benefit analysis, let's get it right, including for intangible injuries, bring in, provide a role for the Office of Management and Budget to work, including with the Federal Trade Commission, of course, which is an independent agency, but there should be a voluntary cooperation, I would suggest, between the FTC and OMB, if not, a formal responsibility to consult and coordinate. But let's do it informally and voluntarily in the interests of society.
I think that that's a great goal, Alan, but I find that assessing the costs and benefits of information-related injuries or benefits is exceedingly difficult. And so I don't know how we should proceed while we're trying to figure out how to measure that. But even to give one example that has come up a couple times with Cambridge Analytica, the white paper I wrote about that data breach argued, and I still think that this is true, that even though everyone seems to agree something went wrong, if you actually try to pinpoint exactly what that was, you'll end up splintering people into a bunch of different theories, each of which is, they're overlapping, but often incompatible if we take one of them and run with it in terms of defining what an injury is. And it can't be, well, at least I would argue that it can't be that micro-targeting per se is a problem, or if that's the case, then the internet as we know it is going to be illegal. And so once you start drilling down to figure out where the problem was, I mean, the safest way from a legal perspective to say that something went wrong is to rely on the Facebook's FTC consent decree, where and the argument that they violated it by allowing third-party apps to collect data the way that they did. But that was pretty specific to Facebook and to a specific consent decree, and does not really give us any principles for going forward measuring these things.
So this raises a couple of points. One is, 40 years ago, I know, Alan, you used to work in on environmental issues, and 40 years ago, or 40 or 50 years ago, when we started regulating the environment in a big way, the tools for estimating the costs and benefits of various environmental regulations were more primitive than they are now, and they've developed. One could argue about it and how much they actually do guide environmental regulation. But now it's routine to do a very detailed cost-benefit analysis, at least at the federal level, for any environmental regulation. Do you think at some point the tools will get, obviously they'll get better, but will they get sufficiently better? And will it be routine to do cost-benefit analyses for privacy regulations?
Yeah, I think it will. I think that the focus on data privacy impact assessments and privacy impact assessments under the, since 1974 in the Federal Privacy Act, there's been an obligation for conducting privacy impact assessments for systems of records that contain personal information, in the United States. That obviously applies to the federal government and not more broadly. But I think that there is an increasing acceptance both of the utility of the practice and the feasibility of it to conduct impact assessments both within companies and government agencies. The EU, of course, has stimulated that with its requirement in some cases to conduct privacy impact assessments where material uses of data or novel uses of data. The Washington state legislation, which didn't make it through, contained a privacy impact assessment requirement under certain circumstances and was explicit about its including cost-benefit type considerations. So I think that I agree with Jane certainly that it's very hard to do a cost-benefit analysis, especially where intangible factors not only need to be but must be taken into account, because I do think the intangible factors are crucially important. I don't think it's just economic impacts that need to be taken into account in the privacy realm. But the fact that it's very hard to do, I think, just as you, I think, astutely point out, Tom, at the beginning, it's rudimentary, and then it gets better over time. We get more sophisticated at doing it. And I think that, I believe that the notion of digital governance within companies, corporations, and the commercial sector is really taking root, and the more sophisticated companies, or those that are using data in novel ways, really set up governance structures inside the companies. So the equivalent to again borrow from another federal regulatory realm besides environmental, but in the healthcare or food and drug area, where institutional and clinical testing, where institutional review boards are set up either within companies or within educational institutions that are doing clinical research. There should be these types of ethical data review boards in companies that review privacy impact assessments, and that do so taking into account some of the intangible impacts, and maybe consider, what sort of micro-targeting are we doing? What sort of information are we using? And that there should be some some principles that these review boards, these governance structures, these impact assessments, including these factors, be conducted, and that, perhaps in the event of abuses be surfacing, that would be available to the enforcement agency and the company's judgments, the adequacy, sufficiency of their governance structures can be evaluated, and perhaps under a section, unfairness type standard, which bakes in cost-benefit considerations when the FTC thinks about bringing an enforcement action. There's definitely a weighing of consumer harms versus the benefits of the business model or the technology in practice. So yes, very hard, but as you say about in the environmental context, we started out doing it quite badly, and we ended up now doing it, I think, reasonably effectively in that context. But in the privacy realm, legislators, for example, don't even try. They don't even try to assess the impacts, the harms and the costs.
So, Liad, you're at the FTC now, and you're an economist, although you're not part of the Bureau of Economics, but I'm sure you talk to those people all the time. What without betraying any confidences, are they doing any work that would help with cost-benefit analysis of privacy issues, or?
So let me just say, these are my opinions, and they don't represent those of the commission or any of the commissioners. There,
What I'm
in my
saying
opinion,
doesn't represent TPI.
right. There is a shift, I think, towards building in privacy into products from the ground up. And I think there's also an enforcement shift towards making sure that that happens, that it enters at an early stage into products rather than into a disclosure statement that consumers don't bother to read. So I think, initially the focus has been on obtaining consent and having disclosure. And I think now the focus has shifted into using best practices as of the present time when the product is developed to build privacy into the product, to kind of, to use a GDPR term, privacy by design, right? I think there's been a shifting focus towards that. And I think that's probably the right thing to do, because we see that consumers don't bother to look into these disclosure policies. Just to give an example, a large company adopted an opt-in menu after GDPR began to be enforced, and 96% plus of consumers just chose, I'm giving everything to the firm. A small percentage chose to look at the menu of available choices. For example, I'll give you data on this, but not data on that. And had an intricate choice. But the vast majority didn't even bother to read the form. They just breezed through it and gave away everything. So I think there's kind of a shift into making sure that the right protocols are in place, that consumer data is treated properly. And my hope is that this will become the norm, and that any new legislation that might come at the federal level will focus on some of that. Kind of to go back into the original question here about cost-benefit analysis, I think there's absolutely a focus on doing that. There's a focus on looking at harms that can be quantified, for example, identity theft or breaches of sensitive information, or revenge porn we mentioned earlier. So I think that there's certainly a focus on things that can be quantified, that can be justified with an economic model, that there's clearly harm there, and that there should be remedies. Now, is that easy to do in all cases? No, but there are cases where it can be done, and that's, I think, has been the focus.
So, yeah.
Could I respond? I would agree with the idea of improving our measures of information harm and benefit, and of doing either privacy by design or privacy impact assessments. If I, as a matter of both habit and legal requirement, if I were more convinced than I am today that there is a critical problem that is causing consumers the same types of problems that environmental that environmental toxins and pollution do, because even Cambridge Analytica, which is sort of often raised as the key example of what has gone wrong with digital society, does not seem to me to provide such evidence of sort of catastrophic problems. I am not sure that it's worth the effort that it will require to develop these tools. And I worry that privacy, at least the privacy impact assessments I've seen so far, are done in a pretty superficial way that doesn't really acknowledge that, if there's a privacy interest, it's because there is a direct and opposite interest in in accessing the information. That just makes, I think that kind of is the key to why privacy, first of all, just interests me intellectually, that it is in direct tension with other uses of information, and then also just why I think it is uniquely hard.
So let me, you actually wrote a draft privacy law, and I'm curious, maybe as a non-lawyer, maybe all these terms are very obvious to lawyers, but so how would something like a duty of care, how would it actually work in practice? And what would the relationship be between what you mean by a duty of care and the concept of privacy by design, which has been around for a while.
Yeah, I actually, it may not be that different from privacy by design. It depends very much on what we mean by privacy by design, but the duty of care would require a company that, that engages in data collection and data processing to avoid foreseeable risks of concrete harms to their consumers. And by concrete, I adopt everything that Alan said about it not having to be, economic, tangible harm. And so it's really sort of my draft legislation was meant to be a refinement, but also just a sort of codification of what the FTC has been doing and is doing with increasing sort of force and will in the recent years. Sorry, I forgot if there was a second question. I don't remember what it is now.
Well, we're talking about how it relates to privacy by design, but
oh yes, okay. So I did want to say something about that. The problem with privacy by design, at least as it's commonly used, is that it is more of a prophylactic, but it is a. I mean, any duty of care that requires some amount of, considering what is and is not foreseeable is a prophylactic as well. But privacy by design is often used in a way that assumes that we want to minimize any collection, sharing, or use of data that we can't anticipate in advance is going to be directly related to the purpose for which we're collecting it or that we think we might need it for. Liad, you can sort of correct me if the FTC sort of sees privacy by design differently from that. But this means, is that a roughly?
I think it is. I think it's slightly different, but I get the point you're making. I think I borrowed that term to kind of give it some sort of structure, but I didn't mean the exact GDPR approach to privacy by design. Obviously, it's just about using best practices for managing data.
Yeah, so and so if those best practices are very conservative, which I fear they would be, then it, then again, I think that the well-intended regulatory or even just cultural shift toward using them is going to cause more harm than good, or at least that's my prediction.
So maybe to give a more concrete example, in the context of, say, COPPA, trying to obtain parental consent for letting a child use a service, you're expected to use best practices for obtaining that consent, whether that requires getting a credit card or something else to verify that an adult has given consent, something like that. You're expected to do that. That's the rule, right? That's what you have to do. So I think that's kind of the idea, even in non-COPPA settings, to use best practices for managing data in a responsible way. That doesn't necessarily mean minimizing the amount of data collected, but securing it, using good encryption, things like that.
So just to clarify something in my mind, or maybe for the audience as well, is for Alan and Jane, I guess, when you talk about concrete harm, is that the same thing as material harm? Something that would have changed the way you act in some way?
Yes, in the material in the FTC sense or the Securities and Exchange Commission sense of changing the decisions of a reasonable investor, or in the FTC context, a reasonable consumer. Yeah, I would think that's absolutely right. Although, the impacts on individuals do depend on what they know is happening, so that a degree of disclosure and transparency is critical for the public or consumers, as our focus would be here, really need to have some understanding of what's going on, because otherwise they may not be in a position to change their behavior because they don't know what impacts they're being subject to. So, and you asked earlier what why do we need a new law, in the U.S. at the federal level, other than to kind of keep up with the Joneses in the EU? Well, there are benefits to transparency and disclosure, because without that, where the digital arena is as complex as it is, and it's hard for really people even involved in it to understand it, thoroughly. So greater transparency and disclosure, I think, is helpful. I don't think it should be, such a weight that it, brings the economy down. But yeah, additional transparency and disclosure. And the reason that I clarified what type of materiality we were talking about, because I don't think it needs to be material harms in the sense of pecuniary or materialistic harms, but it can go to things that, to impacts that people are not comfortable with. If people are not comfortable in having certain of their, internet activities subject to, surveillance for sensitive health sites or other things, well, I think those might be factors that companies should take into account, and regulators, if there are abuses, should also take into account. But I think it really comes back to, I would say, on a foundation of transparency and reasonable disclosure, that we're talking about a governance structure here. And in the first instance, companies, organizations ought to do it for themselves. And if they're, if they fall down on the job of taking into account these various factors, then I think regulators ought to step in, but they ought to step in where really the harms are, material, or, if you go back to, Spokio or the standing analysis, where they make a difference. Not that they're, de minimis or, so insubstantial that, yeah, in theory, maybe there's some people who are bothered by it, but basically, most reasonable consumers who know about the practice are, relatively reasonably comfortable with it.
Jane, you looked like you wanted to say something, or?
Yeah. And in fact, that definition of materiality, which I agree with, it's pinned to what consumers. I think it requires more than just a level of discomfort. It means that consumers, if they were well informed ex ante about risks and benefits, they would have actually done something different. And that, I think, sheds some light on what to me is so troubling about GDPR and CCPA, is that they both involve a non-discrimination requirement, where companies, it's unclear how these are ultimately going to be interpreted, but companies need to treat people who have opted out of data collection the same as those who have opted in. And that means that consumers are put in a position where they are expecting to be able to have services of the same quality and at the same price as they were before, but without giving data. And that is not, that kind of distorts what we mean by a material change. If consumers would have pursued some option because they thought it was worth it in exchange for giving up some of their privacy, then there really shouldn't, and there really hasn't been a material harm by the offering of that service.
Let me just see, apparently there are a few questions. Let me just see because we're basically at the end of our time, but let me see. I think, well, here's something. I don't know if you guys want to address this, but it may not be quite, but get us back to the COVID-19 issue. Can you give your thoughts regarding what Israel has done? It passed emergency legislation to use mobile phone data for tracking people infected with COVID-19, including, well, I'm sure you you know what it's done. You want to, and this kind of gets into my last question, which, and I know none of you guys is an epidemiologist, but how important do you think the use of data will be, if you want to express it, in addressing the coronavirus thing, and perhaps equally as importantly, you know, in evaluating, you know, what we've done right and what we've done wrong in the aftermath?
Well, I just want to say real quick that data has already been very useful in this crisis, both in assessing, you know, through, for example, smart thermometers where there are hotspots of fevers, or even looking at whether consumers are abiding by, or I should say citizens, abiding by local restrictions, staying home or going to the grocery store or going to the parks, and whether those restrictions should be adjusted.
Am I correct that if you use one of those thermometers, you have to opt in? I don't know exactly.
Right, right, yeah, absolutely. So it's also been used and de-identified in aggregate form to see how many people within, say, a county are abiding by local rules or state rules, to see if those rules need to be adjusted, or maybe specifically in that county, maybe more police presence needs to be there in order to make sure people are abiding by those rules. It's also, you know, being used just through search trends to see if certain areas are searching for more, you know, symptoms or things like that. So I think it's already been very, very useful. The Israel case is very interesting. I am somewhat familiar with it in that they are sending messages, as Lynette suggested here, to people saying you may have been in contact with someone who is infected or was themselves in contact with someone who was infected, and you should self-quarantine for 14 days. There have been scams as well, though. People are sending fake messages like that, maybe to get people out of the house and rob them, right? So there are some obvious concerns there about nefarious uses. It might also, the same data could also be used, you know, for other purposes that are not intended, right? So there are concerns with it, absolutely. So in terms of how data will be useful with this crisis going forward, I'm certain it will be very useful. Just based on the current indications, it seems to be critical.
Jane or Alan, you want to?
Well, I would suggest that that there ought to be something like a Privacy and Civil Liberties Oversight Board in connection with government uses of you know, of data outside of the anti-terrorism context. It really does, I think, make sense as the current situation reveals. There are very important and beneficial uses of location data, but there also ought to be limits. And you know, the society is going to be comfortable with certain measures to keep it safe. That may include some monitoring. But I think that in the United States, comfort with wholesale location tracking, well, you know, I think that would be something that the public would probably feel better about if there were some oversight where there's balance, you know, where somebody in the federal government is charged with the responsibility of considering that balance. And honestly, I would say right now, we don't have any such person. And by the way, that goes for privacy, data protection in general. Well, I've said at the outset that I think the Federal Trade Commission does a great job in exercising its judgment and prosecutorial discretion and taking into account a range of factors. It is an independent agency. It's only you know, responsible for a certain sector of the consuming public, and there isn't any agency, any official in the administration, you know, at a high level in the executive branch whose purpose is to consider the balance of privacy and the other factors, innovation, the economy, consumer choice, free speech, et cetera. I do think that one of the reasons that the Europeans seem to overtake us in public consciousness as privacy experts and privacy concerned jurisdictions is because they have all these regulators and they're single mission regulators who are not seized with the balance, but it looks like you know, they're doing stuff, and doing stuff seems to a lot of people better than holding back. I do think we would be well served with having a federal oversight body, a federal coordinator that can take maybe without regulatory authority, but that can help help the public understand the balance in some of these situations, including the one we're in now, where access to data to fight the virus is very useful, but we don't want to tip too far over into excessive surveillance.
So to Alan's point, I think it's interesting to look back at 9/11 again and note that the relaxed wiretapping laws that were adopted in states ended up primarily used for narcotics-related offenses, not terrorism.
Yeah,
Jane,
so
word.
the Israeli system, let's assume for a minute that it is effective and not sort of counterproductive in the ways that Liad suggested it could ultimately be. I agree it is a slippery slope, but right now we're living on a slippery slope. I mean, so many rules, even constitutional rights that we normally have are put on pause right now. And I get that one issue with data collection and use is that it may be, it may have significance and value to the government if it wants to abuse its power later. And so for that reason, oversight seems right. But I do think it's important for officials and for academics as well to make clear that yes, a government that is in a state of emergency that can force us all to stay home can also do what appears to be reasonably effective to the virus using personal data, including cell phone data and geolocation data. And it concerns me that in Europe the March 20th advisory on GDPR explicitly said that cell phone data, which is covered by the e-privacy regulation, cannot be shared for public health purposes until member states legislate, and then even the legislation still has to, of course, comply with proportionality and whatnot. And so that's one reason, at least my understanding is that's the reason that Germany, which is trying to roll out an app for its citizens, is doing so on a voluntary basis. And at least one study I saw suggested that for a system that's voluntary to work, you'd have to have, sort of enormous amounts of participation, something like 60%, and even, and then you can imagine how there might be some selection effects and problems with that. So I just think it's the time to say that when we're facing a crisis, yes, oversight is good, but time is also of the essence. And then one last point is that I think that coronavirus is going to ultimately be very useful in forcing us to get realistic about the standards of anonymization. So for the last 10 years, in fact, the main reason I got into the field of privacy law was because some social science and econ research I was doing wound up being marred by the debates over whether data is sufficiently anonymized. And there have been, many reports in the public media that, even 4 pieces of geolocation data can be used to de-anonymize people. Many of these reports, by the way, really, really exaggerate what the true risk is. But even accepting that, yes, anonymized data always will carry a risk of re-identification, that's not a good enough reason to prevent data from being shared and studied so that we understand what has happened and what is happening, so that we don't have to live in a void of information, which breeds its own problems.
Well, that's great. Okay, I want to thank all of you. I think this was a very, very interesting discussion, and thank you very much for participating.